The American legal system operates under a structural logic that has shifted significantly since the founding, even while the text of the Constitution remains unchanged. While the stone architecture of the courthouse still stands, the operational code running the system has been modified. On the surface, the continuity of the Republic appears intact. Courts convene, legislatures enact statutes, and legal professionals continue to use the language of the Constitution. The Government Accountability Commission identifies this condition as operational supersession, a state where administrative functionality supersedes constitutional limitation while maintaining the outward appearance of continuity. Fixed constitutional boundaries, which require government to prove its jurisdiction and valid delegation, have been displaced. In their place is a system of procedural management and institutional efficiency. This creates an administrative reality operating inside the inherited skin of constitutional legitimacy. To identify this shift, we must isolate the difference between law as a rule of right and the modern reliance on procedure as a tool of management. Under the Anglo-American common law tradition, lawful authority is strictly bound. It must derive from a chain of valid delegation, traceable to the people and exercised for the public good. Power does not arise from institutional assertion alone. Procedure operates on a different logic. It is a managerial system that measures legitimacy through institutional efficiency and internal rule following, rather than conformity to fixed delegated rights. This structural breach is visible across three pillars of the justice system: the defense function, the prosecutorial apparatus, and the seizure of private property. Distinguishing law from procedure clarifies how the operational reality of a republic can shift toward an administrative state. We begin with the first pillar, the structural modification of the Sixth Amendment right to independent counsel. At the time of the founding, counsel was defined as a privy advisor. This was a private representative chosen by the accused to assist in defending against a public accusation. Common law treated defense counsel as an independent barrier. They stood outside the coercive machinery of the state, interposing themselves between the citizen and the government. The modern system classifies defense attorneys as officers of the court. They are required to hold state-issued licenses and operate within an administrative guild regulated by the judicial framework they are tasked with challenging. Through unified bar structures, the defense function is structurally dependent on the state's approval. This creates a conflict of interest. The requirement for adversarial defense is compromised when the advocate must weigh the accused's interests against competing institutional demands. The Supreme Court, in cases like Glasser v. United States, established that the Sixth Amendment requires representation free from conflicting institutional obligations. Yet modern licensing structures build that conflict into the profession itself. This dependency is reinforced by a legal education system that trains students as institutional technicians, experts at navigating procedural frameworks, rather than advocates who interrogate the lawful source of state power. Modern defense counsel is structurally subordinate to the administrative demands of the system they must resist. The second pillar involves the administrative expansion of prosecutorial power. Historically, criminal prosecution required direct, localized accountability. Accusation arose from identifiable injury and community grievance rather than a self-contained government enterprise. The process was constrained by a sequence. The independent grand jury acted as a barrier to public accusation, and the independent petty jury was the requirement for adjudication. In the modern framework, these independent juries are bypassed. Criminal disposition now occurs overwhelmingly through procedural negotiations. The proliferation of statutory codes and the dominance of plea bargaining give prosecutors the leverage to force settlements before a trial ever begins. Modern prosecutors function as permanent administrative managers of regulatory compliance, coordinating with courts and law enforcement within a self-contained system of case disposal. Consolidating investigative coordination, charging discretion, and procedural leverage into a permanent office neutralizes the jury. The people are removed from their role as a check on state coercion. Criminal adjudication has shifted from a public trial into a closed-door managerial negotiation. The third pillar involves the shift in due process constraints on property rights, seen most clearly in civil asset forfeiture. In a constitutional republic, government is a fiduciary instrument established to secure pre-existing rights. Taking property requires the state to meet its burden of proof through the law. The historical sequence is fixed. The state must establish jurisdiction, prove individual guilt, and obtain judgment before taking a citizen's property. Modern administrative forfeiture reorders this sequence, seizing property through quasi-civil mechanisms before a criminal conviction, placing the burden of recovery on the owner. This creates institutional circularity, where procedural operations validate and fund their own authority through internal mechanisms. Under statutes such as 28 U.S.C. Section 524C, agencies participating in seizure operations are authorized to retain portions of the proceeds they confiscate. This creates a structural financial incentive. The institutions exercising coercive authority benefit from the expansion of that authority, independent of criminal adjudication. This revenue cycle circumvents fundamental limits on delegated power and bypasses constitutional legislative appropriations. When enforcement agencies fund themselves through the deprivation of citizen property, the government functions as a self-sustaining confiscation machine. These three compromised pillars, counsel dependency, the bypass of juries, and self-funding enforcement, form the operational boundaries of administrative governance. These represent a unified operational logic that is currently superseding the Constitution. The institutional architecture favors procedural efficiency, closed negotiations, and regulatory compliance over the friction of constitutional limits. Authority derived from institutional practice or procedural normalization carries no lawful force. A procedure operating beyond right is void. Preserving the outward forms of a republic does not prevent the operational reality of arbitrary power. Restoring lawful governance requires a method to verify authority beneath the procedural facade. The article proposes Operation Firewall. This is a constitutional verification methodology applied directly to the administrative legal system. The mechanism required to test administrative overreach is called sequential inquiry. Every government act must survive a specific sequence, tracing authority to a lawful source, proving valid delegation, demonstrating strict jurisdiction, and operating within due process. If any action cannot pass these exact checks, it is illegitimate fiat. Power in a free society must continuously prove its subordination to the people and the limits of its delegation. Restoring justice involves forcing the system to demonstrate its authority at every step. Procedure operating without constitutional boundaries is simply tyranny by process.